Good morning. My name is Jeff Cunningham. I'm an attorney at Goldberg Segala LLP, and today we're going to be talking about cyber-based legal malpractice claims, defenses, risk management, and ethical issues. The talk today is going to discuss the three main sources of risk that attorneys are facing and the overlap of those sources of risk. I like to think of these risk groups as a Venn diagram with the legal malpractice claims that attorneys face as one circle, ethical considerations and ethical violations, the potential risk there, as another circle, and then the new and evolving technological risks, cyber risks we see every day in the news, not just for attorneys, but for everyone now, especially in the new normal following COVID. The cyber risks is a third circle in our Venn diagram. That area, those three areas of risk are something attorneys have to deal with every day in all areas of practice. But it's really the overlap of those three sources that we're going to talk about today and should be a primary target for risk management for any attorney. A course overview, we're going to talk about that intersection of risk for the center of the Venn diagram. Practical advice for risk management techniques, best practices that you can use in your practice, no matter if you're in a huge firm, solo practitioner, in-house. Going through kind of the day-to-day what you can do to address cyber-based claims and ethical considerations. And then sort of some homework is to develop a plan today. So no matter what area of practice you are in, no matter how much technology you are using, no matter what jurisdiction you're in, you should leave today's talk with an idea to develop a plan, start a plan, whether it's put down on paper or not, whether you assign team members to a risk management team or not. You'll have some idea as to what to do before a cyber-based claim and associated risks become a real problem. Talking about cyber threats, I like to break down the two traditional sources of risk to attorneys: ethical violations and malpractice claims. Overlapping those two sources of risk is the cyber threat. But first to talk about ethics and malpractice and how they differ. Our ethical obligations are enshrined in professional ideals. Malpractice claims are based on common practice, the common practice of an attorney in your community and practice area. Ethics violations generally involve intent. Malpractice is negligence-based, so it's a mistake. Ethics involve typically a course of conduct, not just one instance, whereas malpractice claims are the other way. They're based on one instance, and if you have a continuing course of conduct of negligence, you're going to be exposed to multiple malpractice claims. And then finally, the ethics claims are handled by the state bar associations, the grievance committees, and in the local jurisdictions. Malpractice claims are handled by state courts, federal courts to some extent, but applying state law. So those two traditional sources of risk, ethics and malpractice, again, overlap with the growing, and it's growing exponentially, the growing risk of cyber-based, technological-based claims against attorneys. So kind of an ethical overview, the duty to disclose malpractice, I think, is always the best starting point from the ethics standpoint. It's where the two sort of ethics and malpractice sort of meet. And the ABA model rules apply. Your state ethics rules apply. ABA Opinion 481 provides that a lawyer is required to inform a client if the error is material. Now, whether the error is material, there's some wiggle room there, but generally speaking, the ethics rules do require disclosure of malpractice or potential malpractice. The Restatement Third of Lawyers also requires attorneys to disclose malpractice. And then on the flip side, the majority of jurisdictions do not require an attorney to disclose malpractice. There's a minority of jurisdictions that do, but most jurisdictions do not require disclosure. Always important to keep in mind when discussing disclosure of potential malpractice is the failure to do so the failure to disclose potential malpractice to clients could expose the attorney to other claims, especially breach of fiduciary duty type claims. But there are other claims out there, and each case is, of course, specific. But the failure to disclose could expose the attorney to other potential claims due to that failure. And there's also malpractice insurance considerations. I'm an insurance defense attorney, and your professional liability carrier should be involved in the discussion from the moment you suspect that there could be malpractice, or even exposure to a meritless malpractice claim. You want to talk to your insurers. They're a great resource. Also, it could trigger notification provisions in your policy. But if you decide to disclose or apologize or admit or essentially do anything as it relates to a potential claim from one of your clients, that could impact your insurance coverage. So you want to bring the insurer in right away. And we'll talk about that a bit deeper down when we start to get into the cyber-based claims and the cyber threats.